Hello, I'm Professor Christine Coughlin. As you dive into the first weeks of law school, you'll have to adapt to a level of academic rigor and challenges that you haven't faced before. As you heard earlier from Professor McClurg, many professors use the Socratic or case method to ask challenging questions in class about a case or legal concept. While this may sound nerve-wracking, you need not worry. It is possible to survive and thrive on answering questions in class by using a technique called case briefing. This technique can make the difference between struggling or succeeding in your exams and in law school. What is a case brief and why should I care? A case brief is a synopsis of a judicial opinion that captures its key elements. In non-law school language, a case brief is a set of notes outlining the major details of a case that you read for class. Your law school textbooks are case books. They are typically filled with appellate court judicial opinions specifically edited by the casebook's authors. Many times, it feels that these cases are written in an entirely different language. You have to read each case to carefully dissect the important components of the case. It is the process that you learn by briefing your cases that is extremely valuable. Why does this process matter? With all the things going on in law school, hours of reading, a new apartment to settle into, and that person in criminal law that you hope to grab a coffee with, why should you put extra time into briefing your cases? While commercial briefs and outlines can certainly help in your studies, they can't replace the extra time and effort spent by students who have prepared briefs for themselves. For instance, you engage in the analytical process by identifying and categorizing the important aspects of a case. When you dissect that information from your case and summarize it in your own words, you recount the thought processes you had when you originally read the case. This prepares you for the challenging questions your professors will ask you in class to determine whether you have a grasp of the legal principles at the core of the case. Your class preparation and the professor's challenging questions hone your ability to think like a lawyer. As nice as it would be to have a single template to brief all of your cases, reality isn't that simple. Each professor and each area of law presents unique challenges. You need to find the method that works best for you in the context of each class. To do this, you need to understand how your casebook works. Most casebooks are divided by topic. These broad topics are in turn broken up into smaller subsections that cover specific legal questions and issues. For example, a casebook section on intentional torts may contain chapters on intent, basic kinds of intentional torts, and different defenses against intentional torts. So, one way of finding out how the case fits into the grand scheme of a subject is to look at the table of contents or class syllabus. Once you've figured out the context of the case, then you'll be able to read the case. You'll need to be comfortable with reading slowly and carefully. While you're reading, you may want to highlight, underline key ideas, make margin notes, or write your notes on a separate page to recall key details. Make sure to consult a legal dictionary or other outside resource if you have trouble understanding a legal term. Although there is no single format, most case briefs include these categories. 1. The major parties. Each case will involve different people, groups, or entities. Keeping track of which party is doing what and who is suing whom will help you sort out what is happening as you review the facts of the case in your brief. 2. The relevant facts. We all know that person who loves to tell stories about the drama in their life. We could probably go back and boil down their entire tale into one short paragraph after cutting out every unnecessary "Billy said that Susie said that Tommy went to the store and..." Similarly, your case brief should focus only on the facts and details that are relevant to the legal issues in the case. 3. The procedural history or posture of the case. The cases that you may read in law school will typically be appellate-level cases. Summarizing what the lower courts did will help you understand what issues the current court is addressing in this particular case. 4. The issue. The legal issue is the substantive legal question that the court is examining. If you can't figure out the legal issue from the case's text itself, look at the table of contents or notes in your casebook after the main case. Those notes and questions often talk about the issue that you're trying to spot. 5. The rule. The rule is the legal principle that will be used more broadly in the future as a result of the case. The rule is often bound up with the court's answer or holding concerning the narrow legal issue decided by the court. And 6, the court's reasoning. The majority of legal text in an opinion is the court's explanation of why it chose the particular legal outcome that it did. Remember, there is only one person that is important when you work on your case brief: you. Don't worry that somebody else has a different method. If your way of laying out case briefs gets you the results you want, then you don't have anything else to worry about. Now that you've had a chance to learn about case briefing, let's take a look at the case Robinson versus Lindsay, a Washington State case from 1979 that many law students read during their 1L year. You can find this case reprinted in Chapter 11 of your 1L of a Ride book. Robinson examines an exception for children to the standard of reasonable care. Earlier, Professor Levitt discussed how the law of negligence centers on the word reasonable. People are expected to act reasonably under the circumstances to protect others from risks that their conduct creates. But reasonable people can and do disagree on what is reasonable conduct. Moreover, what's reasonable depends on the circumstances. Now that you have an idea of what to expect, pause the video and read the case. Now it's time to draft your case brief. Remember the 6 basic categories of information: 1. Parties, 2. Relevant facts, 3. Procedural history, 4. Issues, 5. Rule, and 6. Reasoning. Pause the video, take some time to draft your case brief, and come back when you're done. Great! Now that you've got a sample brief, let's compare it to the 3 sample case briefs in Chapter 11. Each of these briefs were written by students who rose to the top of their class, so they're all good examples. One thing to keep in mind is just how short the sample briefs are. They each contain only the most basic and important information required to understand the case and the final ruling. This would generally be between a half and 1 page in most circumstances. Pause the video and compare their briefs to your own, but don't edit your brief just yet. Here's a quick rundown of how the 3 briefs stacked up. Each brief accurately recognized the parties as the 2 young children in the case. They each also identified the relevant facts, though Sample 1's summary was the most complete. The procedural history was a little confusing in this case. As a result, only Sample 1 had an accurate summary. All 3 briefs identified the issue well, though Sample 2 did so more broadly in the context of the standard of care as applied to children. All 3 briefs also identified the rule, though Samples 1 and 2 did it best by adhering very closely to the language the court used when it stated the rule. And finally, Sample 2 nailed the 2 essential legal reasons the court gave for the ruling, while the other 2 briefs missed either one or both. No doubt you've found areas of your own brief that could be improved. And you may have also identified some areas that compare favorably to the samples. If you found your own brief to be lacking, that's okay. Learning how to brief cases gets easier with time, and you'll become better with each new attempt. Remember, the more you brief your cases, the better your legal analysis skills will be. So take a deep breath, relax, and get ready to succeed in law school. You're going to do just fine. Let's proceed to the self-assessment.